Live now. Thank you everyone for attending our webinar today addressing diminished capacity and cognitive impairment among financial professionals. I'm really excited to talk about this with my fellow panelists who I'll introduce in a moment. Just as a matter of housekeeping, I find panels are best when they are interactive, and certainly the panel members will do our best to be interactive. I know in a virtual forum, sometimes it's difficult for the audience to interact as well. But I would really encourage anyone, if you have any questions that you would like to pose to any of the panelists, please use the chat and Q&A functions at the bottom of the screen, and I will do my best to monitor those and to work those into our conversation so that we are addressing what you guys as the audience want to hear about this very important topic. So we'll begin with our panelists. My name is Joelle Sims. I'm a principal at Bressler, Amory & Ross based in the Dallas, Texas office. Formerly in the Fort Lauderdale, Florida office where I still do some work. I am also the co-chair of Bressler's Senior and Vulnerable Investor Group. So this is a topic near and dear to my heart that I am very interested in and enjoy speaking on. We also have Matthew Penfield, who is also a principal at Bressler, Amory & Ross. He is in our Birmingham, Alabama office, and he focuses on employment, labor and employment litigation, as well as general litigation. We next have Kyle Ennis, who is an Associate Director for State Government Affairs at FINRA. We have Ron Long, Head of Aging Client Services for Wells Fargo. And last but not least, Kristen Standifer, who is the Licensing and Examination Supervisor for Washington State Securities Division. And as you'll hear today, played an integral role in the NASA report on this topic that we will go over today. So what are we going to talk about today? First, we'll discuss unique financial industry concerns in this space, challenges for firms in addressing these issues, identifying suspected impairment, practices and tools to deal with that, and what role, if any, that regulators have to play in this rapidly evolving subject. Now, why are we talking about this? Why is this important? So first we have here the aging workforce by the numbers. I'm sure it's no surprise to anybody who's tuning in, but the percentage of the workforce in general, as well as at financial institutions, is growing. So you can see here the workforce age 55 and older has been steadily increasing over the years, and that obviously is expected to increase. Also by the same token, 1 in 10 people in the US who are 65 or older have Alzheimer's dementia, which is obviously of concern when you're dealing with diminished capacity and cognitive impairment. Now, while that's maybe what most of us sort of think of when we think about these topics, that's not it. We're also dealing with cognitive impairment that may be caused by other issues. It could be by a change in medication or could be by substance abuse. And as I'm sure everybody who's tuning in is aware, we have an opioid epidemic in the country right now. There's also alcoholism is a big issue too. And as anybody's probably seen in the news reports, that has only increased in this COVID environment with the stresses of working from home, changes in routine, things of that nature. And so we have here some other statistics. The past year substance use disorder among finance and insurance industry full-time workers. We can see that typically afflicts the younger segment of the workforce there, although certainly there are some in the older segment as well. And then we also have past year substance use disorder among full-time workers. We can see that in finance and insurance that actually is not on the higher end, but still a substantial amount. So I'd like to start, and for those in our audience, some of you may have seen the Professionals with Diminished Capacity report that NASA put out earlier this year. And that really called attention to a lot of these issues and a lot of the stuff we're going to discuss today. We're going to review a lot of what came out in that report and use that as a starting point and a springboard for our discussion today. But to kick it off, I'd like to have Kristen tell us a little bit about the report, what it looked at, and just kind of give us a few highlights.
Thanks, Joel, for including me in this discussion today. I'm excited about being able to present on this report. In the Senior Issues Committee, we were discussing issues that we see that senior investors are facing. And we came around to discussing, recently I had been on an exam where I observed a financial professional who appeared to be exhibiting signs of diminished capacity himself. I don't think that this was related to dementia. I think it was related to substance abuse, but the result was the same, which is the investors potentially weren't being protected or could be harmed. And it turned out that there were other regulators who also had observed a similar thing. So we wanted to study this topic to determine what's the scope of the problem. Is there an issue in the financial industry? Understand what impediments firms would be facing in addressing the issues, and also to help support firms and provide guidance as to what tools and other support we could provide to the firms.
Okay, great. And let's talk about what unique concerns there are. Obviously, this can happen among any segment of the workforce, any segment of industries, but what are the unique financial industry concerns? Kyle, can you talk to us a little bit about that?
Sure. Although I think to really understand those concerns unique to the financial industry, you really have to talk just a little bit more about what Joelle was referencing at the beginning, that this is, the industry has done a lot. FINRA has done a lot. NASA has done a lot looking at cognitive decline and financial vulnerability in clients. And, started there for a number of reasons. Just you want to protect your clients, and that's for NASA and FINRA just essential to the mission. Firms want to, again, protect their clients because that's central to their ability to do business. So we have a lot of lessons that we've learned as part of that process that firms can now take and use to look inwardly from a, just a regulatory perspective and a firm process perspective. So this is an issue that affects everyone everywhere, and we're not necessarily talking about older individuals or even just substance abuse. I've done some work with a researcher out in New York City, a clinician, who talked about how some of the leading causes of diminished capacity or cognitive decline are diabetes and heart disease. The inability to get certain oxygen levels to the brain. It plays a really big role in this. So once you understand that, this is a situation that's basically part and parcel of the human condition, you really start to understand how pervasive this is. And so the concerns from a financial industry level aren't really just one thing. It's in everything. It's how a very, very basic part of being human and aging and living and dealing with things like a pandemic just affects your ability to do day-to-day business. And there's going to be, and so it's going to touch on almost every one of your regulatory compliance pieces. So again, just, I'm not going to read everything that's on the slide, but the standards of conduct, your continuing ed, who you're training, your books and records, fraud concerns. As Kristen pointed out, any advisor with diminished capacity or some sort of cognitive decline is going, they're probably not up on their books and records. Record keeping is incredibly important, and if they're not making those, that's a huge concern for firms. If they're not adhering to the now particularly heightened standards of conduct that firms have to comply with, that is also a concern. And quite frankly, when it comes to FINRA rules, our supervision requirements, if you have an advisor out there who's advising clients and they're really not able to tell you, who they are, where they are, or what day it is, that's going to raise concerns in an exam. So really looking at this kind of from a global perspective, I think is really how folks need to approach this. And
right.
Sorry.
Oh, I didn't mean to interrupt you. I just wanted to jump in there and say, you're right, Kyle, when we talk about addressing this from a global perspective, because when we look at firms, we're looking at everything from large broker-dealer firms to, you know, small state-registered investment advisory firms. And the issues and how to deal with it are different between each of those. I mean, there's some similarities, but there's also differences. And how the issues manifest themselves will be different depending on the firm and the different considerations.
Now, one issue that I find interesting, and this was raised in the report and we have it reflected in the slide here, is the fraud issue. And so there's a lot for anybody who's done any of the investor protection, senior and vulnerable investor protection stuff, being on the lookout for red flags for exploitation and particularly for fraud. You know, we have the print schemes, the lottery schemes, all these sort of things. And one issue that I found interesting was the question, are financial professionals themselves becoming victims of fraudulent schemes? And are they in turn then passing those schemes or recommending those schemes to their clients? And I think this raises some really interesting issues, particularly on the customer side, which is, do you have an advisor who may be suffering from diminished capacity or cognitive impairment, who then is subjecting the firm or exposing the firm to a potential selling away claim? Are they now having their clients invest in some fraudulent scheme? And so my question is, either to Kyle, Kristen, or Ron, have you seen any of this? Is this something, that's a hypothetical, or is this something that you guys are seeing happen?
I think I've seen this happen, in particular in a state-registered investment advisor, where perhaps it's the worst case scenario. The individual had a change of medication and it was impacting his ability to process information. So we found on exam that he had a girlfriend who lived overseas and had tried to come to the United States to visit him, but ICE detained her and put her in the Drake Hotel. So he was sending everyday money to her to stay at the Drake Hotel as she got cleared from customs. But at the same time, he also invested his clients in a private offering, unregistered, not exempt, and the clients lost money in this offering. Fortunately, when we did the exam, we were able to get in there before and to stop the losses, but it does happen.
Yeah, and I think, Joel, what you raised is a very interesting question. Independent of diminished capacity or dementia, an advisor that falls for the romance scam, is that a professional, even if after it's all been figured out and boy, was I crazy to fall for that? Do you keep that person in position to then manage the money of all of his clients? I think that's a fair question. And as I said, could be raised independent of the concern about dementia, diminished capacity, or some other cause.
And just to add on that and, possibly really scare everybody on this webinar at the moment, there was a study that came out years ago, which I promise you I read, but I have not been able to find it again. But it was looking at who in large corporations, not financial industry specific, is most vulnerable to fraud and those sorts of issues. And it came back and it was your legal and compliance departments. So, I mean, it's not even just the advisor that could be falling susceptible to this, which again, as Ron and Kristen pointed out, is a very real concern. But if your folks overseeing the advisors are also falling victim to this and having these struggles, can be just as problematic.
Yeah, and I think Ron raises a very interesting point, and Matthew, I'd be interested to hear your perspective. Let's say you have an advisor who fell for the romance scam, later on says, wow, that was silly, I shouldn't have done that. Obviously there is likely to be a loss of confidence in that advisor's judgment, whether it's from diminished capacity, whether it's from medication, whether it's from substance abuse or what have you. How do you deal with that from an employment perspective? And does that raise any issues, any concerns, for this person may have an issue that caused them to do this in the first place, but then there's also a loss of confidence in terms of the person's ability to do their job and exercise good judgment.
Yeah, thanks, Joelle. And the hard part about that is all of these are so fact intensive and so fact specific. You've got to walk through the steps as you go through to determine what the employment implications are. You know, firms generally do have the ability and the authority to discipline for performance issues, you know, which at least falling for the scam, you know, if there was a loss of money, doing something that was beyond or outside of compliance, you can discipline or take action based on that. The question is when you say, well, what was the cause of that? And then you've got to get into, as we're going to talk in a little while about, well, is the cause of that an immutable disability that I have? Is the cause of that some illegal drug, which may not have the same type of protection? Is the cause of that something else? And now you're taking the action based on something that the advisor did, a performance-based reason, or is the action you're taking really traceable to more of a characteristic or a condition that is protected under the law? And so the only way you can get to that is, and we'll mention this in a little while, the only way you can get to that is to not take a knee-jerk reaction, but to take the methodical steps you have to take to examine what are the underlying causes that could be present. You may still get to the same response. You may still get to a discipline, and you may still get to a termination, but you've gotten there only after you've slowed down to determine what is the basis for the action that we're taking as the employer.
Okay, thank you. And we're going to get into that in a little more detail. Let's review, Kyle, and I'm going to come back to you, some additional concerns that are unique to the financial industry in this space.
Sure. Well, already led in with supervision, and frankly, I think we've discussed a lot of these at this point. You know, is the advisor making the appropriate disclosures? Are they meeting their are they servicing clients and performing trades in the way that they should be? Is it accurate and timely? And what's the harm to clients of receiving advice from an individual who could be facing diminished capacity? And I think, you know, as Matthew started to talk about, this is a very, very dicey area for anybody to look at. I still remember very distinctly one conversation with a researcher down in Florida who felt very passionately, shall we say, that most practicing physicians aren't able to properly diagnose cognitive decline or medical incapacities, that you really need a specialist to do this. And if most doctors aren't doing this, how can you expect a regulator or a firm to be able to make this medical determination? Which, I mean, the fact of the matter is you can't. So really looking exactly at what Matthew was just talking about, what is the harm to clients? Is it, what are the recommendations that are being made? Is there a problem based on the actions and results? And really when you're looking at firm challenges, that's what you need to focus on.
Now I was going to say, if this was a drinking game, Kyle, it would be the number of times I say documentation, because that's what we're really talking about. Document, document, document. How many password resets did Ron have in the last 30 days? How many trade errors did he have? So, no, the firm probably can't diagnose that Ron has dementia or diminished capacity. But by documentation, they can say, Houston, we've got a problem, and we need to go through some of the steps that Matt will talk about later.
Including perhaps the lack of documentation by the financial advisor documenting the failure to document.
Yeah, and I think we'll talk about this a little more in depth in a few slides, but we did receive an audience question, and I guess I'll let you start with answering, and then Kyle, Kristen, or Matt, if you guys want to chime in. But we got a question about do you typically notice diminished capacity through audits of documentation or through continued supervision and conversations with registered professionals? And I would add to that question, or is it a combination of both?
It is a combination of both, and many times it'll come from the client associate or the CA, the person that assists that financial advisor, they literally start to see the pattern that's somewhat off kilter. But you'll also see it in, I mean, the extreme case is, for whatever reason, he or she's reached a point where the only thing they remember, 500 shares IBM, and every client all of a sudden, every week is buying 500 shares of IBM. So it's that sort of evidence initially that you might see.
Okay, now let's get to the legal issues and the challenges that firms face in dealing with this. And Matthew, I'll turn it over to you to get us started with the legal issues that we started talking about a little bit, but let's get a little more in depth on those.
Sure, thanks, Joelle. And the reason why these are so important is if the goal is to protect the investor and there's some issues in play, diminished capacity issues, whatever the reasoning from them, firms want to take the appropriate action to protect that investor. But at the same time, what they don't want to do is automatically open themselves up to a lawsuit from that advisor, from that representative, because of discipline, because of termination, because of something else that happens, maybe a reporting requirement. So what we've listed are two of the primary federal anti-discrimination laws that are in this space and that have an impact in the area. The Age Discrimination in Employment Act, ADEA, and then the Americans with Disabilities Act, the ADA. And whenever employers begin addressing issues that could be related to age, starting with the ADEA, they have to consider whether their actions violate those age discrimination laws. One of the areas of diminished capacity impacting the industry, really the country, but the industry, is generally tied to persons over a certain age. You may remember that slide that we showed earlier, that 1 in 10 persons in the US 65 and older have Alzheimer's dementia. And so we know that there is a population that is going to have, most likely to have some of these issues. And firms have to be very cautious that they're not taking an action against one of their employees based on age, or if it even has the appearance of based on age. So what we have is a difficult tightrope walk sometimes, because firms can and should engage their employees who may be suffering from some form of diminished capacity, whether that's a medical condition, an addiction problem, a dementia problem caused by age. But at the same time, when you do that, you have to be careful that you're not all of a sudden trampling on their protected rights under these anti-discrimination laws. So as we discussed before, and as Kyle mentioned, and Ron were talking about, we've got to be aware of some of these red flags, the improper communications, the trading, the changing passwords, the inability to complete continuing education, the list goes on. And when we have an advisor who can't do those, the firms have to step in and take action. But they can't take action in a way that then puts them at undue risk for actions upon them. However, when the firm engages, it needs to do so in a way that lessens their risk. So how do we do that? First of all, and you'll hear this a lot, you involve your HR professionals. That's the first step. They are the persons who have the expertise and the training in how to respond to these situations. You also need to engage outside legal counsel or your in-house counsel to help walk through the steps. Make sure that the words you use in the conversations are well thought out and they're not flippant. Make sure that the actions taken are documented sufficiently. Ron talked about, document. He was talking about document how many times the password was changed or how many times the wrong trade was made. But you also need to document your actions along the way, because you may need that documentation later to justify your actions, and your documentation needs to be contemporaneous to to what's going on and not created after the fact. So even
if I could jump in here for a second.
Go ahead, Ron. Yeah.
To stress this point, that conversation, and I'm one of the big sports analogies guys, to the point that you can't be colloquial and say, Ron, you're losing your fastball, or Susie, it seems like you've got the yips. All of this needs to be very laid out and almost scripted to word for word. And that script becomes a document.
No, I think that's exactly right. And that's, we all just use very casual conversation, but when you're walking into these areas, you need to be very careful about what is said, even more so what's written down. But when you're, approaching someone who may have a cognitive issue, diminished capacity issue, and you're talking about a performance, you need to speak specifically about the performance that's at issue, not in these generalities that maybe can be twisted and used in different ways. That's important not only for the clients that you're protecting, but it's also important for the advisor if you're really trying to get to the root of the problem and say, is there a solution? Which kind of brings us to the second major federal law there, the Americans with Disabilities Act. And as a refresher, employers can't treat qualified individuals with disabilities unfavorably because of that disability. And employers have to be cautious not to treat anyone who is believed to have a physical or mental impairment less favorably. Once again, even under the ADA, employers can and should take action if an advisor is unable to perform their job. But then that opens up a different side of the ADA, and that is employers' requirement to provide reasonable accommodation to employees with a disability. Now, of course, an employer doesn't have to provide a reasonable accommodation if it would cause significant difficulty, expense, or, as the law says, an undue hardship. But those decisions have to be made very carefully and with the assistance of HR professionals. And you have to walk through the right steps. And the risk comes, at least one of the risks comes, when you don't even walk through the right steps. I was just looking at a case that was out of the Northern District of Georgia, and an employer had terminated a 911 operative who had anxiety and panic disorders, and they kind of had a knee-jerk reaction, said, you're not able to serve the client base who calls in, and they terminated this person. Well, it ended up going to a full jury trial because the court determined you didn't even try. You didn't even have that conversation with the person to say, is there an accommodation that we can make here? Maybe they wouldn't have been able to make one, and maybe the facts would have turned out differently. But the law is very clear that you have to at least try. And so you have to do that very methodically. And you have to do so with the help of your HR and particularly in this industry, of your compliance professionals who are going to help you walk through the steps to do that.
Now, Matthew, talking about reasonable accommodations, let's start with the example of someone who maybe has a substance abuse problem or has some medication issue. How would you reasonably accommodate something like that?
Wow, that's a great question. We could probably spend the entire hour, if not more, on addiction and substance abuse problems. And first of all, let me back up a little bit and say, whenever you get into that area, into that realm, it is going to be very specific, not only to the facts of that case, but also the specific addiction and the specific substance. For instance, under the ADA, the law looks at persons with an alcohol problem differently than they look at a person with an illegal drug problem. And when it comes to an illegal substance, they look at the person, whether they are a current user, different than someone who is a past user who has recovered. So first of all, you've got to look at those questions. What is the substance that we're dealing with, and what is it that is protected? For example, generally, current use of illegal drugs is not protected under the ADA. But if someone has had a problem before and they come and they need some reasonable accommodation, maybe it's a treatment center, maybe it's some time off during the day, you've at least got to stop and have that internal conversation to determine, is this reasonable? First of all, is this a disability that we have to accommodate? That's something you have to document first. And if it is this reasonable for us to accommodate? And if it is, particularly in an industry where you probably have the financial resources to accommodate it, you have to then look at, would it disrupt the workplace by trying this accommodation?
Now, what if we're dealing with someone who has diminished capacity or who has, as a result of Alzheimer's or dementia or something that is not going to get better? What kind of accommodations, if any, can be made in those circumstances?
Yeah, so
the hard ones.
yeah, thanks for the easy question there, Joel. That's good. Once again, what's important is to stop back and to take the right steps. There may or may not be an accommodation that fits, depending on what is needed and depending on the level of that diminished capacity. I think one of the things that we didn't really get into, but is probably everybody listening knows this, the scale of cognitive impairments and diminished capacity, it's not just that you have it or you don't. There's going to be a scale there along the lines of what can you do. If you have a person who has reached a point of not being able to engage another and listen to what their financial concerns are, their investment concerns, if you have a person who can't even make the cognitive decisions of managing a process, then you may very well be in the place where you say, there's just not an accommodation that would allow you to be in the workplace here. Secondarily to that, under the ADA, you've got an issue of could that person operate in the workplace without being a safety harm to themselves and to others. And in the industry, the others has to include those clients outside that you're servicing. So you have to look at all those questions. On the other hand, you may have someone with some cognitive impairment that simply just slows down their ability to do some of the processing jobs. Is it possible that they could gain some assistance from someone else in the office? Is it possible that they could partner or pair up with someone else to help do some of those? Those might be reasonable accommodations depending on the circumstances.
Okay, and we've had an audience question, Matthew, that I will give to you, and then I'll move you out of the hot seat in a minute here. But we've had a question that, can you ask for a doctor's note or letter to inform the company what the person can and cannot do?
That's a great question. It was actually something we were going to get to. So in that process, particularly if they are a current employee, a current advisor, and you engage in that interactive process under the law, you can definitely ask for something from a treating physician that says, are they capable of performing the functions of their job? Sometimes that involves sending the functions of the job to that treating physician so that they know what it is that you're asking. And it could actually get to the point where you could have a conversation with that treating physician. So you can definitely do that under certain circumstances, and it depends on the stage of employment, and the law is different if it's an applicant or if it's someone who is accepted but hasn't started, and it's different if it's someone who's currently employed. But it's definitely something that you need to reach out for. As Kyle mentioned, though, earlier, one of the issues is, where is your comfort zone and confidence level when you reach out to that treating physician as to their response? Now, that may provide you some documentation to ease your liability, but it also goes to the question of, does that give us comfort zone as to continuing to work with clients? I think that's a different question probably for Ron or for Kristen.
Okay, great.
I just wanted to jump in there. I'm not going to answer that question. I'm pretending I'm a Supreme Court justice, nominee. But I did want to say, we've had a couple of questions about the independent channel. And I think this has to squarely be in these contracts all need to be reviewed, because we probably, and most probably have it, but you need to have that clause or phrase that allows intervention in the event there's a suspicion of a health issue, however you want to phrase it, but you need to be having it a contractual obligation for that independent BD to communicate back to say, we can have this discussion, we can look through these issues to determine if you can continue being affiliated.
Yeah, and I do want to talk about U5 reporting, because that is a big issue, but I want to kind of piggyback on what Ron was discussing, and we have gotten several audience questions about the HR issue, and particularly in the context of individual advisors. How do you address these issues where there is no HR? What's the best way to go about that? And Matthew, maybe you want to take a stab, or Kyle, or Kristen?
I'd just say early on, even talking about if you do have an HR, one of the big things that you have to look at is finding ways to break down the barriers between HR and your compliance folks or your folks that are reviewing FA activity, so that there's some kind of communication coordination there. For firms that don't have an HR, in some ways, you will have to have someone, and Matthew can clearly speak to this better than I can, that it is fulfilling some sort of an HR function. That's going to make hiring and firing decisions. And unfortunately, I think a lot of it's just going to rest on them. But one advantage you might have in a smaller location is that you don't have, it would be easier to grab all of the information and have access to, what would normally be a compliance role, what would normally be an HR role, or what would even be an IT role. I mean, going back to the independent brokerage discussion that Ron had mentioned, we're going to talk about training a little bit later, but making sure anybody with that kind of global touch point is trained to recognize this or report this or do what they need to do is going to be really important for both the small and the independent brokerage firms. So, if you have some tech folks who the independent agent has, calls up or communicates with, wherever those touch points are, having your employees trained so they can make that referral is helpful in at least the identification portion.
And touching on that. Oh, sorry, go ahead, Ron.
No, go ahead.
I was going to say, touching on that, and we have gotten some questions about this, and we note at the bottom here that smaller remote or one-person offices seem to be at higher risk, according to the NASA report. Kristen, maybe you can speak to this, but obviously there are many firms that function under a core and satellite business models involving remote or single-person offices or maybe two-person offices, and certainly in the COVID environment, we've seen a lot more people go remote. So how can firms deal with this and address these issues? And Kristen, maybe you can speak about what you guys saw in this study, how smaller or independent firms were reporting that they were handling this.
So each firm handles it differently. I think in some instances, there was a compliance consultant that was brought in to address some of the issues or to put some policies and procedures in place to help protect investors. Certainly, I would say reach out to an attorney. If you don't have a human resource department or if you're a small remote or one-person office, the issue that we were seeing with these offices is that a lot of times when you have a representative that's had a client for the long term, maybe they observe some behavior that's concerning to them, but they don't want to report it because they don't want to jeopardize that relationship with the representative, or they don't want to tarnish their reputation with the firm. So instead of reporting the issue, they will move their money. And sometimes they'll use an excuse like, my son has taken over my finances and he is making me move my money to this other advisor. So we found that while sometimes investors were willing to report, or clients were willing to report, they weren't always a very reliable source of reporting. And then similarly, staff in those offices, it was kind of a mixed experience there as well. Sometimes staff was willing to report, but other times, particularly if the staff member was a spouse or otherwise relying on the representative's income, they weren't willing to report. They would, in some cases, they would cover for the individual or would, basically were doing the responsibilities of what the representative should have been doing. So each situation is different. It's very tricky, tricky problem.
Sure.
Yeah,
And
Kristen, I think that, I was just going to say that sort of covering is going to be a big challenge going forward because you're going to have essentially the securities industry version of a weekend at Bernie's where people are trying to keep that income flowing because they are in a single person or this is their source of income. And if Ron's gone, that means I'm out of a job.
Right, absolutely. I just want to interject with our first code for CLE credit. The first word is Bressler. Bressler is the first code word. There'll be a second one at the end. Now I'm going to skip over the U5. I would like to get back to that if we have time at the end. But given kind of where the questions are going, where the discussion's going, I'd like to turn it over to ways firms are addressing this. And so we talked a little bit about the client complaints, but Ron, can you talk to us about electronic supervision?
No, I think this is an area that will grow as well, but electronically, there's a lot of information that comes, whether you're remote, whether you're in a big hub office or what have you. And that information needs to be mined and is mined by compliance. Initially, not for concerns about dementia, diminished capacity, but if the repetition is such or the pattern persists, that may lead you to that conclusion. That challenge is there. There would be other data that you have internally that you compare to peers that let you know if Ron's a little out of kilter on these measurements, maybe we should go in and take a closer look. What's promising in this area, and we're not there yet, but there's some researchers that think they can learn more just from keystroke analysis. The way I hit the keyboard in typing in information is different than the way Joelle would do it. And the way I hit it when I'm healthy, fully there, is different than when I start to have impairments. And so some folks think they can, using just keystroke analysis alone, begin to get an early warning sign that this is a FA that we need to go take a visit to, look at more closely, and what have you. So if we can start using just the electronic medium to get more information in advance, I think that gives firms at least an edge in trying to get in front of some of these issues.
Sure. And client complaints, I won't go through those because Kristen talked about that a little bit, but I think the takeaway on client complaints is that those really were more infrequent and an unreliable source of finding this information. And what really was kind of the best resource was observations by firm staff and others. So this is compliance staff, assistants, coworkers, other employees who are saying, hey, you know, something's not right. My boss, my financial advisor is consistently entering trades wrong, or I noticed that he's, you know, mixing things up or forgetting clients' names or things like that. And these were discovered in compliance exams, but also just in day-to-day contact. And I think one issue to be aware of this, and we did have one question about whether firms will be required to create policy or provide training and education on this subject. And I will let Kyle talk about training in a moment here. But what the study did find was that, you know, the training that many firms currently do to protect their investors, so the vulnerable and elderly investor training, red flags to look for, is equally applicable to the workforce. And, you know, we gave the examples of the romance scheme earlier, and we gave, you know, those other examples about, well, you know, Mr. Smith is resetting his password frequently. Those are equally applicable. And so I'll let Kyle talk about whether FINRA is going to implement any requirements for training, and Kristen can certainly weigh in on that. But I would say, being a litigation attorney, it's never going to hurt to have the training. And that, you know, if you're doing it, you're going to be picking up on these things faster, and you're going to be putting yourself and the firm in a position where you can identify these issues more quickly. And before I turn it over to Kyle, and I'd also like him to weigh in on this, is we did get an audience comment about the delicate balance between protecting investors and protecting the workforce. And an example being, you know, where one of a financial advisor had suspected diminished capacity. The firm was alerted to it by the advisor's partner. The financial advisor left the firm and then sued, saying that the former partner was slandering him by telling the employer and telling everyone that he had diminished capacity. So Kyle, if you can talk to us about training, and then Matthew, I might want to get your input on how to kind of balance those issues between having the workforce report these issues but also making sure that it's not going to come back to bite you.
Right.
From a training perspective, and I'm just gonna, given the question that was asked, I will say everything I'm talking about today are my own opinions, and in no way FINRA policy or the position of FINRA.
Ditto for all, right?
Right.
So I think when you're talking about a training requirement, FINRA, from a FINRA perspective, I think we have the rules, the regulations, and the laws in place that we need to examine for the issues that arise out of this. So going back to what we were talking about earlier, you know, a lot of the issues are not, you know, if somebody has Alzheimer's, that's one thing, but a lot of the issues that the industry is facing isn't someone who has Alzheimer's. It's not even someone who has mild cognitive impairment. It's kind of the lead up to that where the ball kind of starts to, the ball starts to get dropped. I was trying to avoid the sports metaphor because Ron got on my head on that one and short-circuited a second. So from a training perspective, you know, some states actually are already requiring training. There are requirements that firms provide, some generalized training. I think all the requirements I've seen, bar one, that's a whole nother story, are not state specific, and they're not client specific either. They're just saying, you know, you got to look out for the red flags of diminished capacity, financial abuse. And, you know, we're talking about mostly diminished capacity and cognitive decline today, but there's a whole financial exploitation thing here. We talked about an advisor falling victim to financial exploitation. Remember, in some states, you're going to have a mandatory reporting requirement as a firm to report your employee, you know, falling victim to financial exploitation or potentially falling victim. But that's...
And if I could just jump in, sorry, to plug NASA a little bit. I mean, we have our NASA Model Act in which requires firms to train their individuals on the red flags of diminished capacity. Washington State has had their statute in place for over 10 years. It was one of the first in the nation. In addition, 2 years ago, the Senior SAFE Act was passed, which requires certain financial institutions that want to use protections, a safe harbor under the law, to train their employees on the red flags. So there is already some required training out there. And there, you know, NASA has trainings available on their website as well as other organizations that, and it's available.
Yeah.
I'll toss it back to Matt, Chris, but I think we want to be careful to not have train your folks to look out for the old advisor who might be slipping. That is just going to be a recipe to have. It's just not a lawsuit. It'll be class action, and firms will be in deep trouble.
So if I implied that the training would only look out for the red flags of aging individuals, I apologize. The red flags apply to anyone at any life stage or any age. It's not age specific.
And
on that point, oh, sorry, go ahead, Kyle.
It's really important that, you know, we're talking about these things, and there is definitely a correlation with aging here, but this is not an age-based problem. We should not be looking at age-based solutions, though all solutions, I think, have to be age-sensitive. You do have to keep that in mind for the reasons, you know, Matthew was talking about earlier. And just, if I can go back to the training really, really quick, one of the things that I think everybody should really think about is who you're training and what touch points you're training. Going back to the small satellite offices or the independent broker or the independent model, or just frankly, all models, insurance, whatever, it doesn't matter. Wherever you have touch points, I think it's valuable to train. One thing that a lot of people don't think about is in some of the slightly complicated internal compliance processes, like your anti-pay-to-play policies, or requiring FAs to pre-clear political contributions. Those people pre-clearing those contributions and approving those are going to have touch points across that industry, and, you know, might be able to spot some things for you.
Yeah, and if
Yeah,
I
and
can...
I wanted, oh, sorry, Matthew, I'm going to put you in the hot seat again with what
right.
I asked you, but I have more questions. And I really appreciate we're getting a lot of audience questions, which I'm really pleased about. Kind of touching on what Ron and Kyle and Kristen have said, We've had some questions. Number one, should firms create some kind of yearly test for all employees to try to identify diminished capacity issues? And the second is, can you focus special electronic monitoring efforts based on age? For instance, can you do special monitoring for FAs over 65, or do you have to rely on daily supervision identifying potential issues across all ages?
Yeah, so
Go
ahead, Ron.
No, go Matt. Well, I was just going to say quickly, I will eventually have to take an eye test every year to continue to have my driver's license. Stanford University requires all physicians at 70, starting at 70, to undergo an annual competency exam. So even though I was the one worrying about age, Sully Sullenberger was, 4 weeks from being able to not fly anymore when he landed that plane in the Hudson. So there are age requirements in a number of industries, and I can just see some friendly lawyers out there starting to say, why wouldn't you have had Ron get tested a couple of times? You knew he was 72, and look what happened to my account.
And I think that the concern, I mean, and we all can see that the concern is any test that is in the industry that is going to signal out a certain category, particularly a certain category of protected individuals, is going to be problematic. In this particular instance, and I think we've all echoed this throughout the seminar, the issue and the concern is diminished capacity and cognitive impairments. That's a broad category. And so the tests, the more they are geared towards discovering those issues, the less you run a risk of creating a problem on the age side, particularly under the Age Discrimination Act. I also wanted to jump in and say, when we were talking about the training and reporting earlier, the more training we do, which I think is always necessary, and we always say that on the employment side of the law too, the more training you do though, the more we may also end up with people actually communicating what they think are issues. The question, Joelle, that you raised, that someone mentioned, the FA who reports their partner as having some issue. The more you train someone about red flags, the more someone might see a red flag and decide they need to report it. And so I think the takeaway for that for firms, small firms, medium firms, large firms, is we want those communications to come in, but then the reaction of the firm is not just based on that. Once that communication comes in, all those steps that we were talking about earlier, that engaging the compliance team, engaging HR if you have them, engaging legal, to take the right steps to say, what is the next communication? Maybe it's the interactive process. Maybe it's a question to that advisor. Maybe it's going to the next level and asking, can they perform the functions of their job? But the more you do that and don't just rely on the complaint that comes in, the better off you're going to be if you do decide that action needs to be taken against that particular advisor.
And just going back to the red flags about clients having issues, there was I noticed a comment in our chat here. Context really is king, and everything kind of has to be taken in context or build up and kind of you have to look at it like that.
Right. So I think we've got about 6 or 7 minutes left. So tools and practices. We talked a lot, I think, already about communication, especially involving the HR department, involving outside or in-house counsel. I think the key here probably, and I think my panelists would agree, is to communicate early and often and make sure that you are documenting this stuff if you believe that there is an issue. We also talked about education and training. I think we've gone through that. I'd like, Kristen, if you can kind of talk to us about succession planning. I know that this was a big topic addressed in the report, and can you share with us sort of your views, what you learned, and how this can help firms address this issue?
Definitely. First, I just want to step back. I'm going to claim temporary diminished capacity because I think I said that the NASA Model Act has a training component to it, which I just checked that real quick, and I don't think that actually is in there. So I just wanted to clarify that. While many state acts do have the training requirement, the NASA Model Act does not. As far as the succession planning goes, we saw firms, particularly in the independent contractor model, on the broker-dealer side, but also on the state-registered investment advisor side. Many states, sorry, I'm going to take a step back here, addressing only the state-registered investment advisors. Many states already have a requirement that they have a business continuity plan and a succession plan in place. When we do our examinations, we review that and we make sure that it's already in place. And that applies to anybody at any age and any stage of your career. Now, on the broker-dealer side, a firm has to have a business continuity plan, but the individual representatives currently are not required to do so. But what we are seeing are some firms, particularly in the independent contractor model, are implementing some suggestions that their representatives have succession plans in place and that they start those early. And the benefits of doing that is we found that a lot of times representatives don't want to retire or are afraid to retire because they really do care about their clients. They have this ongoing long-term relationship with them, and they don't just want to leave them to anyone. They want to make sure that their clients are being cared for. And the beauty or the benefit of the succession plan is that it allows them to put that in place before they're in a situation where it's necessary. So before they're experiencing the cognitive decline, so that they have to deal with the cognitive decline and also figure out what's happening to their clients. So it gives them a peace of mind and helps them to transition out of the business. And it's good to have for a rep at any age, because you never know when you're crossing the street and you could get hit by a car, or your medication gets changed and it causes cognitive impairment. So implementing that at any age is helpful.
And I'd like to get to the role of regulators in a moment here with just the last few minutes we have. But one question I would like to ask about succession planning is, succession planning is great if you have it in place, but what do you do if the advisor who you think needs to move on doesn't want to, or denies that there's any sort of capacity issue, or that he or she needs to take a step back? I don't know, Ron or Matthew, if you guys want to field that one.
Well, I think from the employment law risk standpoint, I think something that Kristen said is really important is it may have the side effect of benefiting in this area of diminished capacity, cognitive impairment, but if the succession plan on behalf of a firm is really across the board to cover all issues, you're going to have less risk, you're going to be able to push it out, and you may not have quite as much pushback from specific advisors. You're going to get pushback if someone feels like the succession plan is being pushed on them because of some capacity issue. And so the more you can make that a broader recommendation to all areas, the more helpful it's going to be from the legal side.
Sure. And I'll give the last code now. The last code is capacity. And with the last couple minutes we have here, I'd like to get into the role of regulators. And the Nassau report basically said that everyone thinks that regulators have a role to play, ... So what I'd like to spend the last few minutes talking about is, what is that role? We just talked about succession planning, how there's business continuity plan requirements for firms, but not individuals. Let me start with Ron. And what role do you think regulators have to play? What role would you like to see them play in this space?
Well, may not have time for the like to see them play, but the role they're going to play is close to Halloween, and they're going to scare us, because it's going to be like that fugitive scene where Harrison Ford says, "I didn't kill my wife," and Tommy Lee Jones says, "But I don't care." And the regulators are not going to care what the various rubric is behind whether you did or didn't see the FA falling or in decline. They're looking out for investor protection. And that scary role actually probably is their biggest and most important role today.
So Kyle and Kristen, what do you envision as the role of regulators? Is there, we had an audience question about, are firms going to be required to implement training on this? We discussed is there going to be an individual mandate for succession planning? What role do you guys see here?
I think that from my perspective, this is kind of an issue that has a lot of pitfalls too, but I want us to be able to support the firms and whatever tools that that comes in, whether that's enforcement or, I mean, we've had firms reach out to us and say, look, we think we have this independent contractor model and we think this representative might be suffering from diminished capacity. Could you do an exam and tell us what you think? And we did an exam and we thought the person was suffering from diminished capacity, but we had concrete examples. We weren't labeling the behavior. We were giving the examples of the harm to investor or the risks to investors. I think that it's one, we wanted to start this conversation with the report, and I think it's, you know, kind of feeling each other out, having regulators work with firms, et cetera, to kind of figure out together what tools are needed and where we go from here, and how do we best support the firms while also protecting investors.
All right, I think we're just about at the end here, but Kyle, I will give you the last word on this if you'd like it.
I was just going to say, I think Kristen hit the nail on the head on this one. We're going to be doing what we always do, and this is just one wrinkle that has to be addressed when it comes to exams, investor protection, and then, you know, firm support. So, you know, and for firms out there looking at this, again, going back to the fact that there are a lot of resources and research being done on, you know, just financial exploitation, diminished capacity, kind of decline in general. The FINRA Foundation, I'm going to throw in a quick shameless plug here. FINRAFoundation.org has a knowledge we gain section and a number of reports on, you know, what decline looks like, who's at greater risk of decline, and that sort of thing. And just if I can temporarily fulfill Ron's promise here, I think one of the scariest things we've ever seen is a report out of the University of Iowa that said that as you age, at some point, 1/3 of adults will develop a condition that leaves them vulnerable to poor financial decision making. 1/3. There's 5 of us on this panel right now. Hi, everybody.
I've already got my third filled out.
I've already shown my diminished capacity, so.
I always joke that half these red flags are probably flagging me for folks too, so.
All right, well, I think we are just a couple minutes over. Thank you so much to all the panelists. I personally really enjoyed this conversation. I thought it was very engaging and interesting. I hope the audience enjoyed it as well. I appreciate those of you who sent us questions. Thank you. You will receive an email with the information to get CLE credit. This webinar was also recorded, so if you had to step out or take a call and want to rewatch it, or if you just found it that riveting that you want to watch it a second time, you'll be receiving information on that as well. So thank you, everybody, and I hope everyone has a great week.
Thanks, Jill.
Thank you.
Take care.